every state has statutes that limit the landlord's rights to upon default. Make sure that the language in the lease is consistent with those state statutes. If the tenant is a franchise business, you may need the landlord to approve the franchisor's required signage. Can the tenant terminate its lease before its scheduled expiration date? Most landlords will allow this, provided that A, the tenant gives sufficient notice, B, that they agree to leave the premises in broom clean condition, and 3, the tenant pays an early termination fee, which...
Welcome back, and thank you for joining us for part 2 of this presentation. Again, my name is Nina, and I'll be the moderator for this presentation as well. To kick things off, I want to go ahead and reintroduce our speaker, Cliff Enico. Cliff Enico is the leading expert on legal and tax issues for entrepreneurs, known for hosting Money Hunt on PBS and writing a syndicated column, Succeeding in Your Business. He is also the author of multiple books on entrepreneurship, crowdfunding, and small business law, as well as writing legal treatises for Thomson West. With a 45-year legal career, he has represented over 15,000 small businesses and previously worked at top New York City law firms before establishing his own practice in Fairfield, Connecticut. He is the Dartmouth and Vanderbilt Law graduate, an active speaker, YouTube host, and contributor to Entrepreneur and other business publications. This second part will be approximately 1 hour, so be sure to watch the full webinar. And if you have any questions that you'd like to ask Cliff, you can always do so by clicking the button in the control panel at the bottom of your screen and sending them in there. Now, without further ado, here's Cliff to discuss location, representing tenants in commercial lease negotiations, part 2.
Welcome back to Representing Tenants in Commercial Leases, part 2. We finished the first hour of this program on dealing with non-compete provisions. So we'll begin with this. If you are dealing with a shopping center lease, there are 2 things you should do for your clients. You should try to negotiate a non-compete where the landlord is prohibited from leasing space in the shopping center to another tenant that directly or indirectly competes with your client's business. But you should also review the non-competes that the landlord has granted to other tenants to make sure your client is not planning to do anything that is going to interfere with any other tenant's operations. Landlords do not want to get into arguments between their tenants. They want to stay out of that as much as possible. If you do get into a dispute with another tenant, it's going to be you versus them. The landlord is going to want to back off. You should try to define, if you are asking the landlord for a non-compete, you should try to define the competing business as broadly as possible. The landlord is going to try to narrow it to as limit as possible because they don't want to tie their hands in terms of negotiating with future tenants. I have seen leases, especially in larger shopping centers, where the landlord requires the tenant to have a non-compete too, where they will not open another location within X miles of the shopping center. It's up to your client if they want to agree to that or not. Keep in mind, though, that if your tenant is a franchise business and has signed a franchise agreement with a franchisor, the franchisor is going to want to have some say in that matter. Because they have rules saying that they will not allow other stores to operate within X miles of their tenants. Signing a non-compete like that could disrupt the franchisor's plans for expansion. So they may have the right to come in and say something about that. If the landlord refuses to give a non-compete, consider as an alternative a clause reducing the base rent if the landlord leases space in the shopping center to a direct competitor, and be as specific as possible. If your client does not want XYZ company to be in that shopping center mall, put that in the provision, saying, if you do rent to them, then I want my rent cut in half because those guys are going to eat me alive. Make it, and be as specific as you possibly can. If you're specific, the landlord is much more likely to agree with that. Okay, moving on. Every shopping center lease that I've ever worked on has a section says that you, in addition to the lease, you have to comply with the landlord's reasonable rules and regulations from time to time. And in fact, make sure you get a copy of these. Very often, the landlord will not attach them as an addendum or an exhibit to the lease, and make sure there's nothing in there that contradicts the lease. You'd be amazed how many times I see landlord rules and regulations that actually are inconsistent with a provision in the main lease. So if there is, you have to have a conversation with the landlord's attorney about that. In big city office tower leases, watch out for provisions that restrict the storage of bicycles on the premises. This is a big thing now. In big cities, people ride bicycles to and from work. And that's okay, but very many leases say, we do not want you taking the bicycle through the lobby because that looks weird. You have to use the freight elevator. Look out for provisions like that. Window washing. Does the tenant have the right to wash their own windows, or do they have to wait for the squeegee guy to go up and down the building? Food service on the premises. Many leases prohibit the service of food in an office tower lease, but can you have an employee cafeteria? Can you have a snack machine for people who are pulling all-nighters? When I was working in the bowels of a large Wall Street law firm back in the 80s, those snack machines were a godsend, because otherwise you had to take an elevator 40 flights down, to get, food at 3 o'clock in the morning. Pets on the premises. If your client is a dentist's office, for example, can they have a fish tank so that people can watch fish, while they're waiting to have their teeth pulled, that kind of thing. Don't assume that these clauses are non-negotiable, because sometimes they are. And of course, when it comes to pets on premises, you have to have the exception for service animals. Okay. And then last but not least, in an office tower lease, use of freight elevators. Very often, landlords will not want tenants using their freight elevators, 24/7. They will only allow use on certain days and stuff like that, especially when your tenant is doing their build out. Make sure that the contractors have the right to use the freight elevators. Okay, landlord and tenant improvements. Every lease that I've ever seen, every commercial lease has a provision saying what the landlord and the tenant are responsible for in terms of improvement to the premises. These should be as clear as possible. The landlord should generally be responsible for repairs and replacements of the building exterior, common areas, and anything outside of the demised premises. In shopping center leases, the landlord's improvements, make sure there's a clause saying that the landlord's improvements, especially involving excavation, should not interfere with the tenant's quiet enjoyment of the premises. This is very important, especially in shopping center leases. Let's face it, every once in a while, something happens where there's a water main break or something like that, and the landlord has to dig up a portion of the parking lot to fix the problem. Inevitably, that will be right in front of your tenant's front door. Okay, it's Murphy's Law, and it happens a lot. Make sure you put a clause in there saying that if the landlord has to make improvements to the premises, they will do it in a way that will not disrupt the ordinary operation of the tenant's business. The tenant doesn't want to go to the premises to open up one morning and see that there's this huge hole in front with signs pointing tenants to go all the way around the building and come in a back entrance. That's going to kill business for that tenant. Make sure that there's some requirement of reasonable notice to the tenant that this is happening, and that there's some that the landlord will take the tenant's operations into account. The tenant normally is usually responsible for repair or replacement of anything that is within the demised premises, and this may include ductwork for the HVAC that is in the premises. So if there's a blockage of the HVAC ductwork within the premises themselves, that may be the tenant's responsibility, not the landlord. Make sure there's clarity on that. When can the tenant install or remove fixtures? Those of you who remember your Uniform Commercial Code course in law school knows that a fixture is an article of personal property that is so closely affixed to the premises that it becomes part of the real estate. It becomes part of the real property. If your client has a huge safe or something like that. I represent a number of jewelry stores. They have large safes, which are bolted to the floor of the premises. Under what circumstances can the tenant remove these, or do they become the property of the landlord? There needs to be fixtures language here, and the landlord will want to be definitely sure that there's no damage to the property too when you install a fixture like that. The landlord normally wants the right to approve the tenant's plans and specifications. Watch out for language that require the use of the landlord's contractor or a contractor that the landlord approves. If the landlord wants the right to approve the contractor, make sure that you put in language saying which approval shall not be unreasonably withheld or delayed. Again, if it's a mom and pop landlord and they just don't like the way the contractor looks, they don't want those kind of people on the property, you can get into some serious trouble there, and as well as potentially a discrimination claim, which you don't want to be in the middle of. Asbestos removal. If the building is an old one, there is possibility that there may be asbestos back there. Who was responsible for that remediation in the event that you break through a wall and you find out we'll talk about the environmental clause in a couple of slides, but this is one of the things you have to be very careful of. Right now, they're doing renovations to the government agency that sets interest rates, the Federal Reserve. They're doing renovations to the Federal Reserve building in Washington, and they just discovered that there's massive asbestos in there from when the building was first built in 1920. So that's creating a major problem now. They have to get an additional government appropriation to do the remediation and do whatever. These could be major, major things. Make sure that there's clear language in there about who's responsible for asbestos remediation in an older building. And again, my favorite topic, HVAC compressors and ductwork. Who's responsible for what when it comes to that stuff? Okay, environmental provisions. Every lease has a huge environmental clause. Most attorneys tend to gloss over it because they figure it's standard language. There's nothing they can do about it. I disagree. The landlord should represent, first of all, that the premises comply with all environmental laws on the lease commencement date. You should not have your tenant lease premises and then discover that there's been an environmental issue that's been going on for 20 years that the landlord didn't tell them about. Okay. The landlord should always represent and warrant that the premises comply with all environmental laws on the lease commencement date. In an office lease, there's not a whole lot a tenant can do to cause environmental damage. So it's probably something that you don't have to spend a lot of time in, but when it comes to shopping center leases, certain tenants may have environmental issues. So hair salons, for example, many states have rules regarding the disposal of dyes and other chemicals. Dry cleaners, the byproducts, if the dry cleaning is actually occurring on the premises, they're not shipping it to a remote location. That is something that you may have to figure out what are your state's environmental rules when it comes to that. Medical and dental offices have very specific rules regarding disposal of medical waste. Most doctors and dentists' office, for example, have a separate contractor that deals with their medical waste than the sanitation company that deals with their regular garbage. That's why you ever see a dental office, they have all those separate bins outside for the medical waste and stuff that's broken down by category. That's because there's a separate service that deals with that than the service that handles their regular garbage. Indemnification and insurance. Try to limit the indemnification clause. This is the clause that says that the tenant will indemnify the landlord for anything that goes wrong within the premises whatsoever. Tenants do not want to be, don't want to discover one morning that there's been vandalism to the premises. Try to limit the indemnification clause. If the landlord gets sued because of something that the tenant did, it would try to see if you can limit it to the tenant's gross negligence or willful misconduct. So, for example, a jewelry store, somebody does a smash and grab. They break through the front window, they steal all kinds of jewelry, and the landlord somehow gets sued because of something like that. Well, that's not gross negligence or willful misconduct. As long as they put adequate security in, the tenant should not be liable for something like that. They should only be liable for things where they honestly did screw up. Although this is why your client carries insurance. Every tenant needs to carry tenant's liability insurance for things like slip and fall cases, that kind of thing. I mean, the indemnification clause is a tough one to push back on. It really is. Another way you could limit it is to limit it to damages or liability caused solely by tenants' acts or omissions, as opposed to related to. The idea here is to limit it to situations in which your tenant really screwed up here, and not just a thing that just happened to relate to the business. So a tenant's customer comes in and starts, firing a gun, all over the place. I mean, as long as your client has made reasonable care to avoid those kinds of incidents, and the landlord gets sued by the relatives of the deceased people. I mean, this just happened in New York very recently. A guy walked into the National Football Association building, and he was mad because he thinks he was damaged by concussions because he played football in high school or something and started shooting people. The landlord might get sued for that. As long as your client has taken reasonable precautions to avoid that event, they should not be required to indemnify the landlord. The insurance should cover those kinds of things. Watch out for language that requires indemnification for the acts or omissions of tenants, contractors, or other third parties. That is frequently included in tenant improvement clauses. It can be a problem, though, especially in a situation where your client has no control over what the contractor does. And also, by the way, too, I mean, this goes without saying, but your tenants should always require their contractors to carry adequate insurance. So if one of your tenants' contractors is negligent and someone slips and falls over a paint can or something like that, and ruins a $10,000 dress or something like that, that's the kind of thing that the contractor should be carrying, insurance for, but try to see if you can limit that as much as you possibly can, because most tenants don't have any control over what their contractors do. If the landlord requires the tenant, which they frequently do, to carry specific amounts of coverage, review the policy limits and other conditions with the client. Generally speaking, it's okay for the landlord to be an additional insured on an insurance policy, but they should never be the loss payee. What that means is by being the loss payee, if there is a claim under that policy, the proceeds go to the landlord, which then handles it reimburses itself, including its legal fees, and then whatever pittance is left over goes to the tenant. You do not want that. If there is a claim, on a tenant's insurance policy, the money should go to the tenant to fix the problem, not to the landlord. Although it's okay for a landlord to be an additional insured. That doesn't usually cost a lot of money. It simply ensures that the landlord's interests are insured under the tenant's policy. Most insurance policies don't require a significant additional premium for that. I always tell my clients, by the way, whenever I look at a lease, I always make a photocopy of the insurance provision. I send it to the client and I say, please send this to your insurance broker, have them look at it and make sure that everything here is okay. If they can get you a better deal, let me know and I'll fight with the landlord and try to get it for you. Always make sure the tenant's insurance broker is involved to make sure that the tenant can, because tenants will say, yeah, no, I got the coverage. Yeah, I got $1 million here, but sometimes it turns out that they don't, or the terms don't exactly match up to what the landlord wants. Get the tenant's insurance broker involved to avoid miscommunication. Okay, the casualty and condemnation clauses. A lot of attorneys don't look at these. I do, however. I have had clients whose buildings have suffered severe damage, due to, in one case, it was terrorist activity. So I tend to obsess a little bit about the casualty and condemnation clauses. And here you have to distinguish between partial casualty and total casualty. Where there's a partial casualty, meaning the tenant can still use the premises, but with some inconvenience while repairs are being done, the landlord should be obligated to repair within a reasonable time, and the tenant should have the right to terminate if the casualty prevents the quiet enjoyment of the premises. Those are the two things I try to get in the partial casualty clause of a thing. Generally speaking, if it's a casualty to the premises, and first of all, it was caused by the tenant's acts or omissions, and if it was entirely within the tenant's premises, the landlord will want the tenant to assume responsibility for repairing and replacing the damage. But if it was seriously, if there's damage to the building that disrupts the tenant's quiet enjoyment of the premises, the landlord should be obligated to repair within a reasonable time. And if the tenant cannot enjoy the premises because of it, then the tenant should have the right to terminate the lease. Now, total casualty is different. That means the tenant cannot use the premises at all until the damage or casualty has been repaired. Rent should abate immediately upon the casualty. I cannot tell you how many leases I see that read, if you read them closely, it says, if there is a total casualty to the premises, landlord will determine whether or not it's going to repair the damage or whether it's going to terminate the lease. And when the landlord has made that determination, rent shall abate. No, that's not right. You don't want your client paying rent for a hole in the ground that they cannot use, not even for a day. If there has been a total casualty to the premises, your client cannot use the premises at all because the damage was so major. They should be able to that they should be able to get a rent abatement from day one. I mean, they're going to be losing revenue for a long period of time. It's adding insult to injury to require rent payment while that's going on. The tenant should have the right to terminate the lease if usually the landlord will say they have the right to either restore the premises or terminate the lease. Make sure you put a time limit on that. You don't want your client even if your client's not paying rent, you don't want your client obligated to remain there and not move elsewhere. Let's say it's a service business like a hair salon. Your client is going to lose business from day one if there's a total casualty to that salon. So they got to be able to move elsewhere and lease another premise and keep in operation so they don't lose business. You don't want a situation where they're required to stay at that location for 3, 6, 9 months while the landlord makes up its mind what it wants to do. You don't want that situation. So make sure that there's language in there saying, 90 days may even be too long. For the hair salon, I would say that if they don't restore or replace within 30 days, the lease terminates and the salon can move across the street. Condemnation clauses, it very rarely happens where a municipality will condemn a building that is already occupied. It rarely happens, but even if there is a partial condemnation, what happens more often is what we call a partial condemnation, where the municipality decides to expand the street in front of the store, so the parking lot spaces in front of the store are removed. So the sidewalk is right on the street there. I mean, that may or may not impact the client's business, but the tenant should be allowed to terminate the lease even upon a partial condemnation. If losing those parking spaces is going to adversely affect the tenant's business, the customers have to park like 3 or 4 blocks away and walk across a busy street to get to the store. That could really seriously impact the tenant's business. So even on a partial condemnation, the tenant should have the right to terminate the lease and move elsewhere, where it's a little bit safer. The default provisions. When is the tenant in default? Okay, or the event of default provisions. Always try to require the landlord to give notice before declaring default for late payment. Very often the lease will say the tenant is in default 3 days, when rent is due on the due date or 3 days after the due date. That's okay. But if your client is still using paper checks to pay rent, and a lot of tenants still do, things do get lost in the mail sometime. I always like to get notice. Although I'm okay with it being a very short period of time. Tenants shall pay rent within 48 hours of receiving notice that the rent has not been received. That's okay. If the landlord did not get the rent on time, remember, this is an existential problem for landlords. If a landlord has a non-paying tenant, that is an existential problem for that landlord. I'm perfectly okay saying that the tenant will walk the check to the landlord's office and give it to the secretary. I have no problem at all saying that, but they should at least get notice before they're put into default and subject to an eviction proceeding. Notice at least 30 days should be required before a landlord can declare a default other than non-payment. If a client lets an insurance policy lapse or something like that, it's going to take at least 30, 60 days to get that policy replaced. You don't want a situation where they can be evicted too quickly. Generally speaking, I always like to include language, and you've seen this in other contexts too, probably, that says landlord can declare default within 30 days or such longer period of time as is necessary to cure the default, as long as the tenant is diligently proceeding to cure the default. They can't sit on their hands, but as long as they're diligently proceeding to cure, they can have as much time as they need to cure the default. Defaults triggered by tenants' bankruptcy. You cannot have an automatic termination of a lease because of bankruptcy. That violates the federal bankruptcy code. So whenever you see a bankruptcy default clause, just make sure that there's language in there saying subject to applicable law or to the extent permitted by applicable law. A landlord is not allowed to terminate a lease because a client declares bankruptcy. There's very specific rules in the bankruptcy code. I seem to recall it's section 547 or 548 of the bankruptcy code that specifically deal with bankruptcy of businesses that lease property. What remedies do the landlords have upon default? The remedy statute. You have to become, every state has statutes that limit the landlord's rights to upon default. Make sure that the language in the lease is consistent with those state statutes. Make sure of that. Try to include language requiring the landlord to give tenant 30 days notice before they convict eviction. Okay, so the tenant is still in default, okay, but the landlord should have at least, should try to see if you can get language in there saying that the landlord has to wait at least an additional 30 days before they can commence an eviction or another proceeding upon default. Again, the goal here is to give your client as much time as possible to get their act together, get their stuff out of there, and move to another location. As much as possible. Try to see if you can get that language requiring an additional 30 days notice. Some landlords will agree to that. They feel that 30 days is not a significant additional period of time. It will give your client enough time to get, if you yourself do not handle landlord-tenant litigation, it will give you at least enough time to find an attorney to represent your client to push back and enforce whatever remedies they may have against the landlord. Do not agree to language, which is actually fairly common, waiving or restricting any law requiring landlord to mitigate the damage. Once the landlord, that clause, while it looks boilerplate, it allows the landlord to continue charging rent even after the tenant is not able to pay rent anymore and is in the process of moving out. Once the landlord terminates the lease, the rent should stop accruing, period. That should be it. That's it. They have an obligation to mitigate damages. They have an obligation to look for other tenants. They can definitely boot your client out. They can definitely evict them, but they have to have the obligation, which is usually required by law, to seek another tenant and hit your client up only for the difference between the two rents. If the landlord relets the premises, the tenant's damages should be limited to the difference between what the new tenant is paying and the fair market rent value, not the rent that the tenant was actually paying. That's an important clause. If property values have decreased in value significantly from the time that the tenant was there, this clause, this language will save your client a lot of money. Your client has defaulted, it's taken a couple of months, the landlord has rented to another tenant for a lower rent. The landlord is going to try to get that delta, that difference out of your client. And putting this language in there, if your client can prove that property values in general have declined in the area over a period of time, this will prevent the landlord from playing that kind of a game. Your tenant should only be obligated for the difference between what the new client is paying and whatever the fair market rental value is of the property, not the amount that they were actually paying. Signage, parking, tenant advertising. These are three clauses in shopping center leases that are almost always negotiated. Signage, make sure your client is happy with the signage that they're getting, but also if the tenant is a franchise business, you may need the landlord to approve the franchisor's required signage. A lot of franchises have required signage that their franchisees are required to use. And if the landlord wants to have, a lot of landlords, for example, want to have the same signage for all of their tenants because it's a very nice look. But if the tenant is a franchise, the franchise will not want that. They will want the tenant to use their signage. Again, whenever you're dealing with a franchise tenant, you got to make sure that the franchisor is involved. And this is another area where the franchisor needs to be involved. The name should be included on the shopping center pylon. That's the thing right as you enter the mall that says, where all the tenants are. Your tenant name should be listed there. In office leases, especially office tower leases, can the name be stenciled on the office door? A lot of offices now are prohibiting this. They're saying, we'll list you in the lobby, on the building directory. We don't want to have an actual sign on the office. Well, in many big city office buildings, you have to walk a quarter of a mile to get from one end of the building to the other. It'd be very helpful to have signs on the door that tell you exactly where you're going. Oh, this is unit 1503. That kind of thing. That's a question that's coming up in a lot of office tower leases. Parking. Will the tenant have dedicated parking spaces? If so, How many? Tenant advertising in a shopping center lease. Can the daily tenant, if it's a deli or a coffee shop or something, can the tenant put the billboard out, the blackboard outside listing today's and daily specials? Believe it or not, a lot of landlords resist that. They don't like the look of that. They're afraid people are going to trip over them. At least it increases their liability. Will two people? You know what the two people are? Those things. It looks like a giant pencil and it goes back and forth and it waves its arms around to gain people's attention. Will two people be See, which they used to call it a tube man, but we can't be sexist anymore. We got to change this. So two people in mascot suits, dress up like a chicken. I mean, I don't know what college you went to, but I actually had jobs like that when I was in college. Standing in a chicken suit outside the mall, waving a thing around. Will they permit stuff like that? I mean, if you are representing tenants like that, it's probably time to change your practice mix. But that's another program that I will do for Justia someday. Okay, rights of third parties, the subordination and attornment clause. Basically, this is a clause that says that if the landlord screws up and the mortgage lender forecloses on the landlord, that the tenant will continue paying rent to whoever takes over the property from the landlord. It's primarily harmless, but I do represent some clients that are in, shall we say, somewhat undesirable businesses like adult entertainment or something like that. No bank wants to be a landlord to a porn shop or a vape shop or something like that. So very often the attornment clause will be drafted in such a way that the quiet enjoyment clause will no longer apply if a bank or other lender takes possession of the property. If you are representing such a tenant where there's an incentive for the landlord to terminate the lease early, make sure you get protection for that client. Again, adult cannabis vape, you know what I'm talking about here. Sometimes pet stores and stuff because of the smells, the odors, that kind of thing. Make sure that the bank cannot take over the premises and then evict your client. Your client should still have the quiet benefit of quiet enjoyment for as long as the lease is in effect. Consider requiring the landlord. I always put this in my subordination clause saying that if the landlord does this, yes, my client will attorn, but only if you get a non-disturbance agreement from the lender or whoever as a condition to the subordination. Yes, but I want to I want a non-disturbance clause from the lender saying that they will not evict my client. Get that from me, and that's fine. I'll attorn. We'll pay the bank. Put that clause in. A lot of landlords will not object to that. Estoppel certificates. This is a document. Every once in a while, your client will call you up and say, "Hey, this landlord sent me something. He wants me to sign it in 10 days. What the hell is it?" It's almost always an estoppel certificate. Basically, they're refinancing their mortgage or they're getting ready to sell the property, and they need all the tenants to sign a document saying that there are no defaults, that the landlord's been a good boy, that the tenant's not suing anybody, that the tenant doesn't have any intention to sue anybody. Basically, it also asks to confirm the amount of the security deposit that's held. Basically, it's not something that you generally negotiate. But what happens if the tenant fails to respond in time? I do see leases where the landlord has the right to terminate the lease if the tenant does not respond to a request for an estoppel certificate in 10 days. And that's really unfair. If the tenant is on vacation, they got clerks, college kids, high school kids running the business. They're not going to know what the hell an estoppel certificate is. It's going to throw it on the boss's desk and wait for the boss to return from vacation. And 10 days could very easily expire. So, make sure that there's something that says what the consequences are if there's no response within 10 days period. And if the landlord refuses that, make sure that the estoppel certificate, the notice clause, has an address that goes directly to your tenant, not to the store. Okay, so that way, if the landlord wants an estoppel certificate, it'll send it to the client's home address or something where the client is much more likely to see it and respond promptly. Assignment and subleasing clauses, they almost always in commercial leases require the consent of the landlord. You should always try to get language in there which approval shall not be unreasonably withheld or delayed. Remember, especially if it's a mom and pop landlord, remember what I said before, they sometimes don't like the way the tenant looks, or the person, the assignee, they don't like the way the transferee looks and they don't want to deal with them. This is the language that will save your client's bacon. If your client is anxious to get out of the business and they find somebody who's willing to take over the lease, perhaps paying a higher rent, The landlord should not get in the way of that transaction, especially franchises. If a franchisee's business doesn't work out, the franchise will often require that the franchisee find another person to take over the business and sell the business to them. You don't want a situation where the landlord can block that from happening. Make sure that this language always appears in the assignment and subleasing clause. If the assignment is happening because of a reorganization, say the client really isn't moving, they're just changing their corporate structure, or they've been taken over by somebody else, that should not re-trigger a landlord consent. The tenant should be able to assign or sublease a lease just by giving notice to the landlord if it's made to an affiliate, made as part of a change in control, or made pursuant to a tenant's franchise agreement with a franchisor. Again, many franchise agreements require the franchisee to sell their business to somebody else if it's not working out. You don't want a landlord being able to block that transaction. If the tenant assigns or subleases for a rental greater than the rent due to the landlord, keep in mind the landlord will usually want a piece of the excess rent, sometimes 50%, sometimes it's 100%. Sometimes the lease will prohibit the tenant from subleasing or assigning to somebody else at a profit. They don't want them making a profit on a transfer of the property. Termination of the lease, holding over. Can the tenant terminate its lease before its scheduled expiration date? Most landlords will allow this, provided that A, the tenant gives sufficient notice, B, that they agree to leave the premises in broom clean condition, and 3, the tenant pays an early termination fee, which is usually 3 to 6 months base and additional rent at the current level, whatever they are. Okay. Can the security deposit be applied to pay the fee? The answer should be yes. If the tenant received a TIA, a tenant improvement allowance, at the lease inception, will the landlord recoup that as part of the early termination fee? Those are the things you have to negotiate. I always like to get early termination fees in my lease because my tenants are usually first-time entrepreneurs. They don't know if their business is going to work. They have no idea if they're going to be around in 5 years' time. And if it doesn't work out, I don't want them having a crushing lease obligation for the balance of the 5-year lease term. I want them to be able to get out with their skin intact. When you're representing a small business tenant, an early termination clause is an essential thing. If the landlord will not agree to an early termination, then the fallback position is to ask for what they call a good person guarantee. It used to be called a good guy guarantee, but again, we can't be sexist nowadays. We call it now a good person guarantee. This is a clause in the guarantee that says that if for some reason the tenant is that at any time, usually it's after the first 2 or 3 years of the lease, as long as the tenant has been paying its rent on time, the personal guarantee will expire after the first 2 years, as long as the tenant vacates the premises in broom clean condition and hands the keys back to the landlord. Now, the tenant is still on the hook, but the personal guarantor is off the hook as long as those things happen. Many landlords will agree to that, as long as they don't want to have to institute eviction proceedings because that costs them money. Okay. If the tenant is still on the hook for damages, but it's just a question of releasing a personal guarantor, that is something that they're much more likely to agree to. Again, it's called a good person guarantee. If you're looking at some older articles online, it's called a good guy guarantee. Find out how they do those in your state, because it's a nice compromise if the landlord will not agree to an early termination. Holding over, this is a provision that says that if the tenant remains in possession of the premises after the lease has expired and they haven't negotiated a renewal, that there's a penalty rate, which is usually 150% to 200% of the base rent. I understand why the landlords want these, and it's not totally unreasonable, because if your client is holding over, they've already made an agreement with a new tenant that's looking to get in there and do their build out, and your tenant is refusing to move. That is, again, an existential problem for the landlord, and they got to get you out of there as fast as possible. So that's why they impose these horrific penalty rates. But the one thing I do like to get into the holdover clause is a clause that says that as long as the landlord and tenant are negotiating a renewal in good faith, there won't be a penalty. The penalty rate will not apply until such time as they decide that this is just not going to happen. and then they'll give the tenant another 30 days to leave or something like that. Because sometimes as I said, in most renewal clauses, the landlord and tenant try to negotiate the renewal rate before the end of the existing term, but sometimes that doesn't happen. Sometimes it bleeds over a little bit because somebody's on vacation or whatnot. You want to make sure that penalty rate doesn't kick in until it's clear that the tenant is not going to be renewing the lease. Okay. The miscellaneous provision at the very end of the lease. I always, a dirty little habit that I have, and not just with leases, but with all contracts, I always read the miscellaneous section first, the general section at the end of the lease. Why? Because when the other side wants to play games, that's where they put them. They put it in the miscellaneous section because they figure, oh, this is the boilerplate stuff. That's all the entire agreement, amendment, modification. Yeah. I'm not even going to look at that. That's all the usual crap. That's the best place to put a sneaky provision because the other side's attorney is not going to look at it. All right, I always look at it first, and I would say 50% of the time, I find something in there. I find something. By the way, whenever you do the notice provision of the lease, make sure that you name yourself at your firm in the notice section. By the way, this ensures that you get copies of everything that the tenant gets. Tenant, let's put it, it's a great way to ensure some additional business down the road. But more importantly, if the tenant is lax and doesn't stay on top of these things, you're getting the notice will ensure that the tenant will not be in default, especially those estoppel certificates that I talked about earlier. Those things always have a tight response frame on that. The landlord always wants response to those within 5, 10, 15 days, and you got to make sure that the tenant focuses on those. And if there needs to be discussion with the landlord, it's got to happen like right away. And make sure that means, and putting yourself on the notice provision, make sure that you'll get copies of those estoppels, and then make sure that you don't go on a 6-month cruise either, because then if the notice is sitting in your inbox and you miss it, then it might be your liability too. Look for sneaky provisions. In office tower leases, by the way, they sometimes include provisions requiring the use of union labor. That is something that you do not have to agree to. You can push back on that. Again, sometimes landlords have deals with certain unions and whatnot. And if that's the case, you want to know about that because that means you may be paying more for certain services than you might elsewhere. Relocation of the tenant in circumstances other than damage and destruction in shopping center leases. I very frequently see a clause in the mission, and they bury it in the miscellaneous section that says at any time upon 90 days notice, the landlord can relocate you to another location within the shopping center as long as we pay your relocation costs. The landlord will always say that we'll pay your relocation costs. But basically, if you've got a prime location, and location is very important to your tenant's business, you don't want to be moved on 30 days notice to floor 6, where with an elevator that doesn't work. Okay, let's face it. The reason why the landlord wants this clause in there is because they think, hey, if I get a better deal from another tenant or a more desirable tenant or a bigger tenant who can pay bigger rent, I want to be able to get this little garbage guy out here and put him up in the attic. Okay. Always resist that clause. Whenever I see that clause, and it's usually in the miscellaneous section, I always strike it. And I will sometimes make it a deal point. I will say my client will not sign this until you get this out of there. They want quiet enjoyment for 5 years, and damn it, they're going to get quiet enjoyment. Except, of course, if there's damage or destruction, and you have to relocate them temporarily until you can repair the premises. That's okay. But if you're relocating them because you're getting a better deal from another tenant, well, then damn it, that's not going to happen. Not on my watch. Termination of the lease should the landlord desire to redevelop the center. Believe it or not, I've seen that. Make sure that if that clause is in there, ask the landlord, when is this going to happen? This is a 5-10 year lease, perhaps. If you need to do upgrades, we need to kind of know about this now. Okay, we can't have disruption of our business. Moratorium provisions. These were very popular during the pandemic, saying that for any reason the landlord is prohibited from charging rent. Rent will continue to accrue until such time as the situation has been lifted. Be very careful. Those clauses can create massive havoc for your tenants. If there's a moratorium provision, required by law, say because of another pandemic, God forbid, or terrorist activity or something like that, your client should not be obligated to pay rent until the situation has been resolved. This is why landlords carry insurance. Landlords' review of the tenant's financial statements. This should not be allowed except possibly where the tenant is paying percentage rent, and then it should be very limited. The landlord should only have the right to look at the financial statements once a year solely for the purpose of verifying that the percentage rent that they've been getting has been accurately calculated. That is the only thing that they should have the right to do. They shouldn't have the right to do a deep dive into the financial statements to figure out if a tenant is starting to wobble financially, which is really what they want. Personal guarantees. If the tenant is a corporation or LLC, the landlord will almost always want personal guarantees from the tenant's owners. If the tenant has minority owners, family members, for example, who own less than 25%, try to exclude them. Try to limit the guarantee to only the people that are actually running the business and who are responsible for the business's obligation, and should always try to exclude transfers for estate planning purposes. So if the landlord, so if the tenant's owner dies and the business now is transferred to a relative, the relative should not be required to sign a personal guarantee unless, of course, they want to. Transfers for estate planning purposes should always be permitted. Try to limit the personal guarantee as much as possible. I always try to limit it to the first couple of years of the lease term, assuming that there is no default during those X years. Or sometimes I'm lucky, I can get it limited to a dollar amount, like 3 months rent or 6 months rent. Again, if you cannot save the tenant, you have to save the guarantor. You may be able to get the guarantee or off with their skin intact. Nobody wants to put a third mortgage on their house to pay a rent from a business that they own. The landlord did decide at one point that they wanted to deal with this company, not the person individually. So there should be some limit on the person's individual liability. And then last but not least, the good person guarantee. The guarantee expires when the tenant vacates and surrenders the premises in broom clean condition. Now, again, assuming no default. So if the client is in default, a good guy guarantee is not going to work. A good person guarantee is not going to work. But if the tenant has been making payments on time and just can't continue the business anymore because of economic conditions, they should be able to get out of the lease by paying a certain sum of money, and giving the premises back in broom clean condition, maybe paying a couple of months rent or forfeiting the security deposit, and should be able to walk away with their personal assets intact. Collateral assignments of lease. This is particularly important when representing a franchisee tenant. Basically, if the tenant defaults under the lease, the franchisor wants the right to bail them out. They want the right to cure the default and preserve the location until another franchisee can come in and assume the lease. Most franchises have a very specific form for this that they want the landlord to sign. Make sure that you include that with the lease proposal or the letter of intent. Do not wait until the day before the lease is signed and then realize, oh, holy cow, the franchise has this 3-page document they want the landlord to sign. That is a major problem, and a lot of landlords do not like these. They do not like the idea that if a tenant is in default, remember, that's an existential problem for them. They don't want to say, well, wait a minute, you have to wait 30 days while we negotiate with this company in California, or some godforsaken place that runs the franchise. They don't want to have their hands tied like that. So they very often will push back on that. If the landlord does object to the collateral assignment language, and they almost always do, have the landlord's attorney speak directly to the franchise to work that out. 90% of the time, they will work something out on that document. And then your client can sign, after all the discussion has been done and the franchise and the landlord have agreed to the terms of it, that's when your client can sign it. Okay, so just keep that in mind. So here are the important points we've covered today. Try to negotiate economic terms of the lease in a lease proposal or letter of intent. Make sure the lease commencement date, the rent-free use period, and rent commencement date are clearly spelled out. Make sure to require a certificate of completion or a certificate of commencement and the tenant right to terminate if the landlord's build-out takes too long. In a triple net lease, be sure to request copies of the previous tenant's bills for taxes, common area charges, and insurance so the client can budget accordingly. In shopping center leases, review the landlord's existing non-compete agreements with other tenants and require a non-compete for your client that's as broad as possible. Make sure the HVAC system works. If you learn nothing else from this program, you know how to handle an HVAC clause. Make sure the HVAC system works and the landlord is clearly obligated to fix any issues as soon as possible. If the premises are damaged, the client's obligation to pay rent should abate immediately until the damage is fixed. Read the miscellaneous section of the lease and the landlord's rules and regulations carefully, as that's where the weird provisions are likely to be. Try to obtain a good person guarantee or limit the client's personal guarantees as much as possible. And if the tenant is a franchise business, make sure the terms of the franchisor's collateral assignment of lease or lease addendum are included in the lease. Make it a part of the lease. Okay. Make sure that that is included. Don't ignore that. So these are some suggestions for further reading. These are some excellent books that have been written. Stuart Saft has written a number of books on commercial real estate leasing and transactions that are very good, especially in understanding the business provisions of the lease. I've got many forms of lease in some of my publications that are available from Thomson Reuters. If you go to thomsonreuters.com and search for my name, you'll probably see all the treatises that I have done. There are some of them right there. And now we can actually take some questions and answers. I know you've had a lot of them here. So in the next 5 or 10 minutes that we have left, I am going to try to answer as many of these as I possibly can. Okay. What about dumpster corrals and dumpster service? Good question. Sometimes that is the landlord's responsibility. And sometimes that is the tenant's responsibility. That's one of the things that you want to look at. It may be covered in the common area charges. In some leases, it may be the tenant's responsibility. In office center leases, most tenants are required to have a garbage removal, a trash removal service, and sometimes they are required to use the same service that the landlord's other tenants use, so they only have to come in at night and they do all the offices at the same time. That is something that you have to watch out for as part of the common area charges. What if the prior tenant simply left a shop that had a certificate of occupancy and only minor changes are needed? Is it easy to transfer the COO? That is a question for your town building department. I do not know. Every town has very specific rules on certificate of occupancy. You may not need an existing, a new certificate of occupancy, or if so, one can issue within a few days if no changes are necessary. But that's a question you have to visit the town building department on. You will have to make some friends at town hall, by the way, when you do this kind of work. And it's a good idea to get to know those people so they will answer your phone calls when you have these kinds of questions. What is the usual process to check zoning to be able to ensure your type of business is allowed, and have you appealed to move a zoning barrier to your premises from nearby or to reclassify the zoning? Obviously, you cannot legally occupy a premises that is not properly zoned. I always want the landlord to represent that the premises are properly zoned for the tenant's proposed use on the lease commencement date. I always try to make them do as much of the work as possible. But if there's any issue about that, you're the one who's going to have to visit the town zoning department or board of zoning appeals. And if a variation is necessary, you need to know how difficult it's going to be to get that before your tenant signs the lease. Once your tenant signs the lease, that rent-free use period term starts ticking. And if they cannot get zoning clearance within that, they're going to have to start paying rent for premises that they cannot legally use. And that is a disaster that's going to come back to you as a potential malpractice action. In 2025, many buildings mid-construction were caught with substantial material cost increases and or sudden loss of workers. How do your leases handle this? Well, again, we're talking about buildings here that are under construction. So, I mean, by definition, your client probably has leased them yet. You're really talking about a situation where your client has begun their build out, and all of a sudden, all their workers get picked up by ICE or something like that. I mean, that's a situation, frankly, where the landlords are not going to be very flexible. That's why you want to have that language that I suggested at the end of that says that the rent-free use period shall be extended, for an additional period of time if necessary to complete the build out, but with a drop dead date where if it isn't done by then the lease, then either party can terminate the lease. That's the best thing you can do to protect against that kind of thing, if I'm reading the question properly. Next question. Many businesses just need to share a facility with necessary equipment as customers arise. Imagine a fertility clinic where a specialty approach supplied by a smaller firm is only brought in as needed. Can the host renter handle all liability and not have to involve the landlord? This is a difficult question. The question really is here, is the tenant subleasing a portion of the premises to this other specialist? In other words, does this other specialist have its own like kiosk? So, for example, my eye doctor, the place where I go to have my eyes examined once a year, has a special place in the back of his office, with a place where you can buy sunglasses, for example, and that is leased. He has subleased to the person that runs the sunglass hut, and that kind of thing. That's the kind of thing. If it's an actual sublease, the landlord's consent will probably be required. But if the person is just coming in and offering services on the premises, but they don't have a dedicated place or anything like that, they just come in and maybe they see the patients in a certain examining room. That is considered a licensee, and the tenant will be responsible for anything bad that happens there. That's why you got to make sure that your licensee has their own insurance, and make sure that they are covered also under your tenant's insurance, so that if they commit malpractice or something and the landlord somehow gets sued for that because it happened on their premises, they're going to want you to cover them for that. That's where they're going to come after you under your indemnity clause. So you want to make sure that your insurance will cover you for that kind of stuff. I hope that answers the question. I think I understood it. Whose responsibility is it to find out if your neighbor tenant has so many customers they hog all the parking spots? Oh, this is a good one. Who determines the threshold to tow the cars from spots? Okay, the second question is easy. That's usually the landlord or the municipality that has the power to decide when they tow cars. But this is something you want to watch out for. I always tell my clients, seriously, before you lease a commercial space, spend some time there. If there's a coffee shop there, hang out there for a couple of days and look at what happens. Look at the traffic flow. When is the parking lot crowded? When is it not crowded? Is there an issue where there's no room for any new parking space because everybody's going to that 110? You need to do some diligence here and find out what the traffic flow is. And if it looks like there's going to be a problem, then your client should insist on having at least X dedicated spaces right in front of the building that the other tenants cannot have access to. Put up little signs saying reserved for XYZ business. You see that all the time in businesses. That's something your client has the duty to search out for themselves. And I always suggest do some diligence, especially if it's in a community that they do not know. Next question. Is it normal that smaller tenants pay 100% of the CAM and the major tenant, grocery store, pays nothing as they are the draw? That is not normal. Okay, I will tell you, I have never seen that. Normally, the tenant should never be required to pay more than their pro rata share of the common area charges. In fact, in a situation like this, I would argue that they should pay less than their percentage share, because the major tenant. The short answer is I have never seen that provision in a lease. And if I were representing the small business tenant, I would say you're crazy to do this. Not unless the major tenant is willing to give you space in the grocery store right near the entrance. Okay, let's have a little branch here. Okay, let's have a little kiosk right inside your main entrance, and then we'll consider doing this for you. That could be a nice, fun way for you to respond to this situation, to point out how absurd that request is. Would a commercial space realtor be able to negotiate lease terms and review the lease like an attorney for the benefit of the tenant? The short answer is it depends on how your state defines the unauthorized practice of law. If in many states the negotiation of documents relating to real estate does require a law license, and in that case they legally cannot. In other states, the broker may be able to negotiate the business terms of the lease, but in my experience, they will not want to actually negotiate the lease terms themselves because they're not trained to do that. They will insist that you have a lawyer do that. They will not volunteer to do that for you. Now, the one exception to that would be the temporary office space, like the Regencies, where you lease by the month. I mean, they have very standard forms of lease. They usually don't want them. They do not want them. They will not make changes. They'll certainly say, well, by all means, have your attorney review it. But this is a standard lease. You're only leasing for month to month here with us, so we're not going to negotiate this with you. And that is their right. You can't do a whole lot about that. But otherwise, the broker should not be negotiating the lease terms. They can certainly help you with the business terms, the economic terms, but they should not be negotiating it. And in many states, they will be prohibited from doing so. Next question. What happens when the landlord lets a fireworks seller fill most of your parking with a tent for a month? By the time you can legally complain, they are gone. Yeah, and that's why they do it, too, because they know they're going to be gone for a month. The short answer is if the tent is set up in the common area, there's not a whole, and they're not disrupting your dedicated parking spaces. The answer is that there's not a whole lot you can do about that normally in most states. I'll just answer that right away. Next question. What type of lawyer should a victim seek help from if they are repeatedly racially discriminated against by another tenant? The answer here is a civil rights lawyer, because they're the ones that handle discrimination cases, or an employment lawyer, perhaps, because they deal a lot with discrimination against. This is a very tricky thing. The difficult thing is going to be to prove that the other tenant is in fact discriminating against you. What I might do in a situation like this is I might call the landlord's attorney and say, hey, by the way, you should be involved. There are some incidents here involving another tenant. They are racial discrimination suits. Please be advised that my client is considering a suit against it. And even though you are not involved, the landlord has not engaged in discrimination in any way. You should be aware there's going to be a lot of adverse publicity for your mall arising out of this. And you may want to consider talking to this other tenant before things get nuclear. That is the way that I might recommend that you handle that situation. Next question. Paying for government required recycling based on square footage, not amount of recycling material, i.e. law firm versus grocery stores, cardboard. Okay, I assume you're talking here about a clause in the lease that requires you to handle garbage removal and that kind of stuff. I mean, normally speaking, you're only required to pay for, if that's included in a common area charge, if that's the question you're saying, and you're saying that this other tenant has a greater amount of garbage than you do with a bigger recycling bill, then yes, I would not insist on prorating this. I would insist on a clause that says that we will get our own garbage removal service. We'll hire our own people to come by and remove our garbage, and we'll put the bucket or the dumpster wherever you tell us to. That could be an example here of, again, making sure that the utilities are separately metered to your premises as opposed to being prorated for the entire mall. Next question. Do you have any tips when acting for a tenant which is subleasing only a portion of the premises in an office tower lease? The answer is yes. You do want to make sure that you get a representation and warranty from your sublessor, the person right ahead of you, saying that this entering into the sublease will not violate the terms of any of the other leases that are stacked up on top of it. Right? Especially in an office tower, your client may be the sixth sublessee, down from the landlord. I mean, I've seen that happen a lot. In a situation like that, you want to be sure that, number one, that this is not in default, and number two, that you have a quiet enjoyment, that sublessor cannot remove you because they are in default under their lease to the next person up on the daisy chain. Okay, those are the two things you got to watch out for there. Then last but not least, when crafting a letter of intent, which provision should I always include to protect my client's provision early on? Well, hopefully the last 2 hours have helped you answer this question a little bit. Don't make the letter of intent too detailed, but if there's something in there that is really important to your client, by all means, try to get it in the letter of intent stage so that it gets resolved early on. So, for example, like I said, if your client is a franchisee, make sure you get a copy of the franchise's collateral assignment of lease or lease addendum document and attach it to the letter of intent, saying, and by the way, this attached document from XYZ franchise is a material part of the lease. Make sure to get it into the landlord's face, and then the landlord's attorney will then get involved and deal with the franchise. That's what you want to have happen there. You want to alert the landlord that you're a franchise and the franchisor has rights here that they need to be aware of. That's the one thing that I think you always should include in the letter of intent or the lease proposal. So I think, Nina, we've nailed all the questions here.
Thank you, Cliff, for all of your insights. And thank you all so much for asking your questions. We always appreciate your participation. We want to thank you all for joining us for another Justia webinar. As I mentioned at the top of our presentations, I wanted to remind you all of the services available to you through our website platform, Justia Elevate. It's our innovative, feature-packed website solution that's designed specifically for law firms. It's built on a WordPress-based platform and offers tools like the Justia AI Writer to help you create content for your website, the AI-powered Justia Chat to enhance your leads, as well as the Justia AI optimization tool built to boost your chances of getting featured in those AI results. So you'll have everything that you need to stand out online. You can visit elevate.justia.com/price to check what your pricing would be today, or you can give us a call at 888-587-8421. Have a wonderful rest of your day. Thank you so much for joining. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.